Let me commence by introducing the panel this afternoon. On my left is Jack Tennier. Jack is the Deputy Commissioner of Canada's Foreign Investment Review Agency and has day-to-day responsibility for the assessment of investment proposals reviewed under the Act. Prior to joining the agency in 1976, he held federal government positions in the Treasury Board Secretariat, the Department of Finance, and the Department of Industry, Trade and Commerce. We're very pleased that Jack could join us this afternoon. On my right, immediate right, is Purdy Crawford, a partner in the Ulster law firm who needs no further introduction. And on my far right, Jim Spence, who was with the agency for 2 years. Jim was a partner in the Tory law firm. The first question that we wish to discuss this afternoon involves the concept of Canadian participation. The Foreign Investment Review Act includes, as one of the criteria for significant benefit, a term, Canadian participation. That term has been interpreted as meaning Canadian directors, Canadian officers, Canadian management, and indeed the ability of an applicant to make equity available to Canadians. Jack, the budget paper indicated that special measures being employed to achieve more Canadianization in the oil and gas industry were not, in the government's view, appropriate for other sectors. Those of us who deal with the agency have learned over the past 7 years that it is often very important for an applicant, in some cases, to be able to give a commitment to make equity available to Canadians. I wonder if you might start our panel discussion, Jack, by reviewing for us the attitude, the approach that FIRA has taken since 1974 and indicating whether or not that approach has changed recently.
Well, I would define Canadianization, we'll define it in those equity terms for this purpose, and that is the process of maintaining or increasing the level of Canadian equity in a Canadian business enterprise. We have several authorities, and I won't spend much time on these, Bob, because you touched on them, and they'll be contained in your paper, I gather. There's the Foreign Investment Review Act itself, Section 22B, that says that among the factors to be taken into account in judging whether a proposal meets the test of significant benefit is the degree and significance of participation by Canadians in the business enterprise or new business and in any industry or industries in Canada of which the business enterprise or new business forms or would form a part. And we have interpreted Canadian participation in the absence of any other further direction in the Act to mean participation as employees, as managers, as officers in the company, as directors, and as owners, and hence Canadian equity participation becomes a relevant factor. There are the new principles of business, international business conduct, which you cited, and one of them very specifically refers says that foreign controlled firms should create a financial structure that provides opportunity for substantial equity participation in the Canadian enterprise by the Canadian public. There's the 50 to 60 Canadian ownership over major new resource projects statement that the Prime Minister made several years ago and has been reiterated in the House on a couple of occasions. And you should know that recently with EM&R we've defined that term major new resource projects as those involving $25 million or more in development and pre-production expenses. They're moving still further into the resource sector. There has been in virtually every proposal involving uranium over the last few years an undertaking given that has well, I'll read it to you. Along these lines, that until the coming into force of legislation regulating foreign ownership of uranium properties at the extraction stage, the applicant will not participate in the extraction of uranium from a property in which Canadian ownership is less than 67%, unless federal government policy should permit a greater level of foreign ownership. And then the National Energy Program, as you pointed out, singled out uranium and spoke about the 67% level. There is a recent statement in August of last year by our minister, the Honorable Herb Gray, talking about major projects. You may know that there's a focus in the last 6 months or a year or so on these so-called mega projects, in which he said that among the objectives was increased participation in major projects by firms beneficially owned and controlled by Canadians. And finally, there's the culture industries that you cited, and there have been several statements, again, as you pointed out, by Secretaries of State, reiterating the sensitivity of that sector and the need for applicants to consider the well, we interpret that to mean the need of applicants to consider the provision of equity to Canadians if they're making a proposal in that sector. So those are the kinds of authorities that we have and have been using. There are a few other situations that seem to call out for the provision of equity. One is when there is loss of Canadian ownership in the Canadian business being acquired. That doesn't necessarily happen. In many cases, proposals are indirect, involving the change in ownership from one foreign investor to another. Other cases, there's a loss of Canadian equity, and that would seem to be appropriate time for an investor to consider making equity available. Similarly, when there's an alternative Canadian buyer on the scene, that might be a time for the applicant to turn its mind to the provision of equity. But I must say that in these two instances I've just cited, when there's loss of Canadian ownership or when there's an alternative Canadian buyer on the scene, the applicant is quite free to seek the meeting of significant benefit through other through reference to other criteria of the Act. Just as I say, it would seem to be an appropriate one to address. And perhaps two others I'd like to cite. One of them involves multi-service or multi-operation service sector proposals. Sometimes investors in the service sector offer proposals and offer services which are not particularly unique or improved upon those that are available in Canada. And when that happens, we're usually hard-pressed to identify that there is any net significant benefit. The main effect of the proposal really is to divide the market in a different way. And sometimes these investors plan to establish chains. And when that happens, it seems to us that that gives rise to a unique opportunity for Canadians to be factored into the running of the business so as to increase the entrepreneurial pool in the country. And so there we see it appropriate that consideration be given to factoring Canadians in as owners of those multi-operations. And finally, major engineering projects, slight elaboration on perhaps what the minister said, but we have many large engineering firms coming into the country, and what we really are looking for is to confer on Canadians the kinds of capabilities, some of which we have, some of which we don't have, and which the foreign investors do. And one way that they can do this so that we're left with a lasting legacy of engineering capability is to take on Canadians as joint venture partners. Well, now, I'd just like to put this into perspective, be very brief, this problem. That is that yes, there is Section 22B of the Act, but there's also A and C. And quite frankly, we would generally prefer, other than in those cases that I cited, a pound of economic benefit to a pound of Canadian participation. So we put a greater premium on job creation, investment, exports, R&D, Canadian sourcing, and all the rest than we do on Canadian participation, not by virtue of the budget papers. I think all that budget statement said is that those very severe or those measures that are being applied to bring about the ownership goal in the oil and gas sector are not to be applied to the other sector. It really hasn't had much difference on our operation. Well, it hasn't had any difference on our operation. I just would like to say, therefore, that we place some, but well, I guess what I'm really trying to say is that Canada is not off on a Canadianization kick, and we should all be aware of that.
Mr. Chairman, I wonder if I could ask Mr. Tennier a question. In my experience with the agency, and it goes back some time, Jack, there's been quite a bit of ambiguity as to what kind of Canadian equity you want. Some of the undertakings are ambiguous as to whether it has to vote, whether participation is important. Would you be prepared to comment on that?
Well, I suppose we take what we get, and so what you may be reading is the undertakings that were given to us. But what are we trying to accomplish with Canadian equity participation? One is a share in the action, and the other is indeed a control in the running of the business, and so control proportionate to the ownership by virtue of participation on the board of directors would seem to be appropriate. I don't know, Purdy. I'm not sure there is a formula.
Yeah, that answers my question.
Jack, I've often wondered myself, in a case involving an application by a substantial foreign-controlled subsidiary operating in Canada with an asset base and an earnings base and a history of earnings, which normally would be in the ordinary course of business in good markets, would enable that company to do a public offering of its stock. Would it be unfair to say that if that company, if that large Canadian foreign-controlled subsidiary, would it be unfair to say that that corporation could virtually not expand into an unrelated field in Canada or make a takeover of another Canadian company unless it made equity available to the Canadian public, or unless it gave an undertaking to make equity available to the Canadian public?
Heavens no. The answer is that remember, our objective is to achieve significant benefit for Canada. We are not mandated, nor do we seek maximum benefit for Canada. So there is granted, it's a judgmental line, but if that company can show Bob significant benefit to Canada in many other ways, through innovative activities, through some export program, through a high level of Canadian sourcing, perhaps one that betters the industry standard, through virtually a limitless number of ways, we would probably not be addressing Canadian equity participation. As a matter of fact, let me say that I tend to go at it last, because there is, I think, in the Western industrial mores, a sense of what's mine's mine and what's mine I'm going to keep. And a businessman understands more when we're talking to him about performing in Canada than he understands giving up part of the company. And one thing we can do easily is, if we drive the process in terms of giving up part of the equity, is to color the whole quality of his proposal. So quite frankly, this is a slightly stronger statement than I said before when I said we're not off on a Canadianization kick. It's one of the last ones to get discussed. I don't know whether that bears out your experience, but the rest of the other panelists, but I can tell you that I'm putting that stamp on the agency, and I'm moving to put a number of stamps, and that's one of the ones I've been working at diligently lately.
Jack, a related concern here could be the experience that some investors may now be having who some time ago gave commitments in connection with their applications, contemplating the issue of stock to Canadians at some time in the future. And the future has now come upon them, and they find themselves in the situation that there isn't a market that they could issue the stock into at a price that would be fair, having regard to their own investment in the company. And that is not only because of market conditions, but also because of the size of the venture. So they find themselves with a FIRA commitment, which they have either breached or they expect that they will breach through the passage of time fairly quickly. Are such situations coming before the agency, and what experience does the agency have in dealing with them? Do you, for example, renegotiate for a new commitment? I'll take the word renegotiate out of there. Do you have discussions leading to a new commitment on equity participation? Do you look for commitments on other matters instead? Do you have, say, an extension of the time for performance on the equity commitment?
Well, you said it. Some of the audience may not know that the Minister Gillespie, when he was Minister responsible for the Act, made what's referred to as the Frisbee speech. He said, if you give a commitment to produce Frisbees and the bottom drops out of the Frisbee market, we're not going to make you produce Frisbees. It wouldn't make any sense. And so that's given rise to the idea of excusing people if they may have caveated or conditioned their undertakings. They may have conditions precedent. It may be that the economy's turned down, and it's the economy turning down that comes into fore here. Now, that isn't to say though that they need be excused, and what we do is have discussions leading to an extension of time. And as to whether it's giving them any difficulty or not, you know, we've been to court and we've been on the doorstep a few times, but not on the issue of non-fulfillment of commitments. Those can usually be extended in time.
Jack, one comment I'd like to make about your agency. That is, I think, is a part of lack of understanding, at least in some of your review people. If you go in and talk about making 10 or 15, 20% available to Canadians, sometimes you get a rather negative response. Well, what's that? What does that mean? But I do think there is quite a significant meaning to it in terms of a multinational company with a major Canadian subsidiary. If 10 or 15 or 20% of it is owned in Canada, they have certain fiduciary obligations, certain arm's length obligations. They cannot, for example, maximize profits on a worldwide consolidated basis in terms of who exports or whether the Canadian company shouldn't export because it would hurt their German subsidiary. And I think there can be quite a significant thing to have equity held by Canadians, vote held by Canadians, even if it's small.
Well, Jim probably recalls the memo, but there is a memo around the agency that says it. I don't think it says it as well as you did, but that's what it says.
Now, I wonder if we could
Dig it out.
perhaps we could move on to our second topic. There has been some concern expressed over the time that it takes to process an application through the review agency. There is no question but that some of those problems fall on the shoulders of those of us who advise our clients. Jack, I wonder if you could indicate what we as practitioners could do to ensure a more efficient and timely review process, and then indicate if any steps are being taken by the agency with a view to expediting some of the smaller cases.
Well, I'm glad you asked. It so happens that for some reason or another, I had to get up very early this morning. Whether that gives people an indication whether I was at the dinner or not, and I turned my mind to this question, and in fact, it's probably the one I'd like to talk to you most about. I guess if I had to summarize it, I'd say be informed, be quick, and use a lot of common sense. So let me go on and explain it. I suppose that there are 2 or 3 situations or categories that exist. For perhaps 90% of the proposals, maybe something a little less than that, but we're dealing with counsel who have had experience before the agency, and they're dealing with proposals that are rather straightforward, that with some imagination they can probably see how it could be structured in such a way as to meet the test of significant benefit. For another 5%, say, the proposals, they're probably ones that we're still dealing with people who have practiced, who have dealt with the agency before, counsel has dealt with the agency, but the cases are difficult. They can't unravel it, can't quite figure out how to, there's some problem with them. And for another 5% or so, I guess we're dealing with people who are coming to the agency the first time. Well, going on to what do you do about these? For the first this is where we're talking about experienced lawyers who are dealing with cases that they see their way through. I'd urge you to treat it like a one-shot effort, and I'll be talking about this in a minute or two. That is to put your best foot forward in that first application. For the other 2 categories, where we're talking about difficult cases, even where there's counsel, experienced counsel, or where there's new counsel, I would suggest that you get in touch with one of the 3 assessment bureau general directors, or with the director of the small business group, and come in and discuss the proposal even before a notice is filed. But for heaven's sake, bring your client with you, because there's no substitute for our meeting face to face. You fellas there, you girls there, but with the client there, the person who knows the business intimately, and it should not just be a representative of the client, but somebody in a decision-making role, so that when ideas are talked about, they know whether it's feasible or not and whether they can commit. So, okay, either way, we get a proposal that's presentable, that has a chance of a good chance of getting through the test. What to do now? Well, any businessman should have a plan. I'm sure he has a plan if he's acquiring a business or he's establishing a new business. And so what you should do, and I suppose you should do this ahead of this, but is to explain to that foreign investor the whole process. Explain the role of the agency, of the provinces, departments, the minister, the cabinet, the governor and council. Explain the process in terms of undertakings, commitments, plans, objectives, use of caveats, conditions precedent, the whole business. Explain it to him, make him very familiar with what's going on, and then ask him with his knowledge of what that process is to put forward a best plan that can meet, and this is the most important part of it, the test of significant benefit. So you'll have taken him through the criteria of the Act. You'll have talked about the 14 principles of international business conduct. And if it's in one of those sectors that we talked about, you'll tell him about the policy pronouncements that there are. Well, then we get to commitments. Now, there I'd say get them in as early as possible, in the sense that if it falls in one of that first category I talked about, get the commitment. You see, ministers are much more disposed towards allowing a proposal if somebody has committed themselves to run the business in a certain way. And this gives rise then to these undertakings. I should think that any investor, for the first while, knows what he's going to do. Granted, further out, they are less prepared. They're concerned about giving undertakings. I'll come to that in a minute. But for the first while, they certainly should be able to give them. And these need deal only with the essentials. For example, we get a lot of commitments that they're going to create so many jobs. We'd rather see a commitment that says I'm going to put into place $2 million, and then when he might speculate that this should give rise to between 50 and 70 jobs, because the number of jobs will follow from the investment. But we shouldn't get locked into defining numbers of that sort, because for one thing, it makes the applicant apprehensive, and secondly, it may give rise to compliance problems down the road. Well, okay, they can't give undertakings through the whole of the piece. Here's where you should be suggesting to them that they state objectives. I think, Bob, you'll recall, not too many months ago, I wrote you a letter about a proposal where we were talking about the balance between commitments and some objectives. The others are softer, they're not as good, but they may be more realistic in the circumstances. And very recently, we've been talking about process commitments. That is, if somebody says that they are going to export some certain percentage of their output, and they may be unprepared to give that as a commitment, and indeed it could be seen to be running afoul of our GATT commitments. What they should do is state that as an objective, but then to demonstrate the good faith that they really are going to do that, they should describe the process they are going to follow to give realization to the achievement of that objective. I'd say just a word on draft undertakings. There are far too many draft undertakings coming into the agency. I'd say by a factor of about 10 to 1. And we've been moving away from them. I'll explain to you how we do have some control over the situation, and I intend to see that we move away even faster. The problem is this. We get a series of draft undertakings, and somebody asks us, are we happy? And we're not smiling, so they go away and they redraft them. And they come back again and back and back and back. The process goes on, could go on for a year or more, and the end result of all that is that the agency is seen to be running a protracted review process. So our suggestion to you is draft, yes, that first time they come in, or yes, draft after that first meeting that I described before that may be necessary. But after that, when you go away, you really should submit the proposal and get them executed. And the instruction that's going out to our people is I'm telling them, not as an invariable rule, but do not get drawn into those discussions on draft undertakings. Just we're paying the price of it, and we're not going to. We've made some improvements recently in how we run our business. We've been given some extra resources, and I don't want to see those dissipated through endless discussions on draft undertakings. 2 other points only, 3 points. Caveats, use of caveats. There is appropriate use of caveats and inclusion of force majeure clauses, but don't overdo it. If you do overdo it, we simply discount it all anyway and tell the minister that the undertakings are useless and unenforceable, and it's as though they weren't given. As a matter of fact, it's probably worse, because we really think that somebody really is intending not to do what they said they're going to do. And the same goes with conditions precedent. We sometimes see them where so-and-so will do such and such, provided that they get a certain volume of sales. It turns out that the volume of sales is 90% of the Canadian market. Not very realistic, so we're going to discount that too. You mentioned, Bob, consultation with the provinces and with departments. As far as with departments, we would very strongly prefer that you not do it. We consult with the departments. As far as I can see, it really doesn't accomplish anything. It spends more time on the proposal. It costs your client more money. I'm not going to counsel you as to whether you should consult with the provinces or not, but We don't favor it. We certainly don't suggest it. It won't work against you in any way. We're not going to hold it against anybody because they have. But again, I really question the utility of it versus spending equal time with the agency in a proposal. Well, finally, it seems to me that what would be useful sometime, and it would be a learning process both ways, would be if on this whole subject of how to go about the assessment process, there were a seminar, probably in Ottawa, probably for a day long. I would deliver all of the assessment officers, so that the 30 or so that they would learn what you people, what's troubling you people, and the questions you have, and they become more sensitive to the process. And I hope you would learn from what we'd learn mutually. Well, Bob, that's why it's a lot, but I did think it was a good opportunity to explain some of the ways which we think you can help out.
Can I make a few comments, Mr. Chairman? One of the problems we have, Jack, and it maybe explains in part some of the delays, is that we have clients very often who start out with some very hard-nosed ideas as to what they're going to do. And it may take several months and some meetings with your people before you reach the point where you can really get them thinking in terms of some commitments. So that it's sometimes difficult to come in early on with a business plan that's made into a commitment or whatever. Another troublesome...
Purdy, let me say, there's nothing like a cold shower to wreck that, and that's disallowance. You know, they get the message very quickly then.
Yeah, but it's not our job to have them get the message that way. The other thing that's sometimes troublesome, and again it depends in part on clients and people, but some people can be pretty free about these undertakings, and they say, well, we can negotiate our way out of it in 5 years' time, don't worry. And others are very concerned and about making a commitment as it relates to a future projection. I mean, Jim talked about going public. A company could go public today and sell equity. Just a question of what you'd sell it for. The other thing about the agency, you say we don't think on the whole it does much good to talk to other departments or to talk to the provinces. The agency doesn't tell the applicant what they're going to recommend to the minister, and and you don't know what he's going to say to the cabinet. Some of these are quite political, and we have no statistics, but sometimes I suspect what happens at the cabinet level is different than what the agency's recommended. And sometimes what happens at the cabinet level may depend upon who spoke to the cabinet ministers the week before. So, you know, it's a complex game. And maybe I can ask you a question. Why doesn't the agency tell applicants what they're going to recommend to the minister?
I suppose I could say because there's an old established tradition of the parliamentary government that advisors do not tell their ministers, tell others what they've told their advising their ministers. But do imagine the kind of situation that it could put him in, and that is we would be saying to you, and as a matter of fact, just on that, I think, what do you think? The three of you went. Wait, let me ask you this. Don't you know most of the time, sometimes, and I suppose you know, the old definition of a sales manager, it's a fellow 100 miles away from home with the big checkbook or the big discount. I suppose I can sometimes be a little more frank, a bit more confident about indicating to an applicant where matters stand. But at the end of the day, if we're smiling and shaking hands and all the rest, and on the other hand, if we've been saying, well, okay, if that's the way you want to leave it, I think they get the message. That's why I'm always surprised when people say, came as a complete surprise. Now, I guess it does in some time. So part of my answer then to you is, okay, we do not say so in so many words, but we do, I think, leave a kind of indication as to how things have gone. And I say, that's why I said, what do you fellas think? You've experienced it. Do you tend to know when it's over and done?
Starting with you, Jim.
Yes, I was going to say I always receive these favorable indications, and I'm glad to receive them. No, the indications are not always favorable, but it is still always useful to receive some kind of indication during the process of how the thing's going, and if there are particular areas of difficulty, to know what they are. And because that seems to me to be a valuable part of the process, I would be concerned if the direction you're considering taking on draft undertakings had the effect of eliminating the possibility of a discussion between agency officials and the applicant's representatives about where the deficiencies and weak spots in the undertakings are. I appreciate that, on the other hand, you don't want to get into a time-consuming process of nitpicking on undertakings. But I think there can be situations in which an investor, in a bona fide way, puts in undertakings which, on examination by the agency, because of economic considerations or sector considerations and so on, the agency considers aren't good enough, and the agency may suspect that that investor might well be prepared in the course of further discussion to step up to some more onerous commitments because of those circumstances. But if you don't carry on that process over the draft document on the table, you may never get to that stage.
You're right, and that's why I have talked with my people about what I call the two-step, because if we've had a discussion and then you've gone away and come back with commitments, and they, I mean, if they fall abysmally short, that's one thing, but if they just didn't reflect the discussion because of misunderstanding, it would be wrong on our part to say, okay, that's it. I think you deserve it, at least our coming back and saying, well, I thought we agreed on this, or that you thought that this would be satisfactory, but your undertakings don't seem to reflect it. To convey that message back to you, you're right. But beyond that, this is where I say I don't think we can go.
Jack, having had dinner with you last night in response to Mr. Brown's question, you're a very warm person, and I'm sure if we had the final meeting with you, we might be able to tell what was going on. But some of your fellows down there is pretty Sphinx-like cool cats. You know?
Well, but look at the problem. There is, and I remember one celebrated case that went on for about a year and a half, and that is that if the applicant says, well, does it look good? We're not going to lie about it. Say, oh, it looks good. And if we say nothing to that question, he pretty well gets the clue that it doesn't look good, and he's going to go away and have another run at it. But that process could go on forever. That's really in part why I suggested the idea of a seminar. I think we're going through this very, very quickly, but if we had a whole day or more where we could talk about what adds up to significant benefit to Canada in certain cases. Bob says there's no sort of logic to the process, but if we took typical examples, then maybe council would themselves have a better idea of what it adds up to, and would seek less our continued advice to them.
Jack, in small business cases, in the past it has been the practice of applicants to set forth in formal undertaking form, really, in the application itself, the plans which it has for the new business or for the takeover. Of recent, the agency seems to be suggesting to those of us who are dealing with cases that even in small cases, the agency's practice now is to almost require formal written undertakings in the same form that they are being used for the long-form cases. Is there any...
I could say it's a gray area, but what has happened is that we have recently created a small business group, and this is a group of several people dedicated to the dealing with small business proposals only. In a way, it cost us money to do that because we did dedicate these resources, but they have been, because they are a dedicated group and becoming expert at what they're doing and acting in a very fast-hitting manner, in the sense that before, small business proposals were wrapped up with all the big ones, and people would have to drop a large proposal and go to a small one. So this other has allowed us to get to the applicants, the council generally, very much more quickly, suggest undertakings, and the result has been a tremendous improvement in the quality of the small business proposals going to the ministers over the last couple months. As a result, whereas last year the rate of 6-4ing, this is where the minister requires more information in respect of a small business proposal, was 40%. It's now down to 15%. It's had the other incidental tremendously beneficial effect to the agency that proposals don't come back in twice. Once is small, once is big, and so the number of cases has been reduced, and we've more than picked up the resources that it took us at the front end to do the counseling. So yes, indeed, we are, and I'd say invariably small business proposals are coming in with 4 or 5 undertakings.